My name is Adam Winkler. I'm a professor of law at UCLA School of Law and the author of Gunfight, The Battle Over the Right to Bear Arms in America.
My name is John Eastman. I'm a professor of law at the Chapman University's Fowler School of Law, and as the director of the Claremont Institute Center for Constitutional Jurisprudence, I've been involved in a number of the cases dealing with the Second Amendment that the Supreme Court has heard over the last decade.
My name is Erwin Chemerinsky. I'm Dean and Professor of Law at the University of California, Irvine School of Law. My most recent book is The Case Against the Supreme Court.
My name is Ben Armistead. I'm the legal editor of the Daily Journal, and I will be the moderator of this discussion. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. What does that mean to you?
Well, of course, that sentence has confused generations of Americans. Many of us believe it protects an individual right to bear arms. Others believe that it protects a right of states to organize militias and to keep them armed, free from federal interference. But the Supreme Court held in 2008 that the Second Amendment protects an individual right to bear arms, unrelated to militia service.
The Second Amendment means what it says. It's one of the few constitutional provisions that states its purpose. It creates a right to have firearms, but for purposes of militia service.
Why do you think that the Founding Fathers decided to include the prefatory clause in the Second Amendment, but in no other amendments?
Well, I think the prefatory clause does explain the reason why the framers thought it was important for people to have a right to bear arms. We think of the right to have arms as an ability to have a gun to protect yourself against an ordinary criminal. That wasn't the major concern of the framers. They thought of self-defense in a slightly different way. They were thinking about having the ability to fight off tyranny if necessary, having an armed population and an armed militia.
I disagree that we'll ever know what the framers intended behind the Second Amendment or any other provision. And even if we knew what they intended, I don't believe it's controlling on subsequent generations. And it's interesting that neither of the others have mentioned that in the earlier draft of the Second Amendment, there's also a clause that would give an exemption from people who are conscientious objectors from militia service. To me, that shows that what the Second Amendment really was about was militia service. There's no indication it was about people having guns on their own.
Well, except the militia was everybody. I mean, this is a key part. And what that the language of exemption for the Amish or for the Quakers, the Quaker exemption, was because they understood that we could actually compel you to keep and bear arms as part of your duties of citizenship. And it was the entire citizenry or the entire adult male population that required to fulfill that duty. The exemption was therefore not to intrude on those who had religious scruples against keeping and bearing arms, but it was never intended to denigrate the notion that the people had not just a right but a duty to do this.
John, you said two contradictory things. You said it was the right of everyone to have guns and the right of all male citizens to have guns. Those aren't the same thing. In fact, if you really want to follow your philosophy, only male citizens would have a right to have guns today under the Second Amendment, which I think shows the absurdity of looking at framers' intent. I also think you improperly equate having guns for militia service and who is a member of the militia. Those aren't the same things.
Recently in Peruta v. County of San Diego, it struck down San Diego's good cause requirement in the case where the court said that self-defense was not a good cause to get a gun permit. So what level of cause it would be constitutionally permissible to require or to allow people to carry guns in public?
I think that's the wrong question. If you have an individual right to keep and bear arms,
can you have any requirement for someone to get a permit?
The government would need to just demonstrate cause not to give it to you, rather than you demonstrating cause to get it. And I think that's the basic difference.
The Supreme Court made it clear in Heller that the government can restrict who has guns, as I said earlier, like to keep people with a history of serious mental illness or people with a criminal record of guns. In order to achieve that, the government surely has to be able to license who has guns in order to be able to achieve that restriction. Also, it's crucial that in both Heller and in McDonald 2 years later, The court spoke only of a right to have guns in the home for the sake of security.
The only reason there's language like that in Heller is because that was what the statute was addressed to. But the language of Heller that talks about the fundamental right to self-defense and the historical discussion that Justice Scalia has in that decision of where that comes from in the common law is by no means limited to the privacy of one home. This is a right to self-defense. And the limitations that can be put on it for felons, for people who are mentally unstable and what have you, does not mean that the burden is on the individual proving that he's not in those categories or that he has some extraordinary need for self-defense that would meet a good cause requirement as was put in San Diego.
All Heller talks about is a right to have guns in one's home for the sake of security. Perhaps the court will go in other cases further, and John has his view that they will, but that's not what Heller says.
That's not true. Look, Heller talks about the right to keep a gun in your own home because it's part of the broader right to self-defense that the Second Amendment was intended to codify and recognize. So yes, it talked about the right to keep a gun in your home because that's what the D.C. statute prohibited. But the language of the opinion and the historical analysis opinion is about this much broader right to self-defense, which is not nearly as confined as that, and there's nothing in the Heller decision that confines it to that, other than that we've got the statute in before us that dealt with the possession of guns in the home.
After the shootings in San Bernardino last week, Congress rejected a couple bills, one which would have expanded background checks and one which would have said that people who are on terror watch lists can be denied guns, which were rejected. A New York Times op-ed this weekend called those bills just the most basic restrictions. So my question is, were those sorts of proposals the basic restrictions or the sorts of limitations on the Second Amendment that Scalia said were possible?
Well, much of the debate is focused on whether we're going to ban people on terrorist watch lists, like the no-fly list, from purchasing firearms. I think such a list and a prohibition, depending on how it was designed, would be constitutionally permissible. Clearly, government has a very strong reason to keep someone who's suspected of terrorism from being able to buy the weapon that would enable them to carry out their terrorist act.
There is no reasonable ground for not having universal registration before somebody can get a gun. The Supreme Court has made it clear, as we've talked about. The government can restrict who has guns. Therefore, registration is the key mechanism.
I disagree with that. Look, we're not even implementing the background checks now. In California, our background databases are a mess. We have background databases for who's mentally incompetent to be able to own a weapon, who are prior felons. Those things are a disaster, and you can't run the background checks when the database that you're supposed to check them against is being incompetently managed.
If the one we have now isn't desirable, that just means we need to create a better one.
Given that the Second Amendment protects the right to keep and bear arms, do you think limiting who can, where you can buy and sell guns would be an offense to the Second Amendment?
I think there's no doubt that we could, the government can constitutionally require people to go through a background check system. What makes gun shows unique is that they take advantage of a loophole in the law, which is that if you're a federally licensed dealer, you have to do a background check when you sell a gun. But you don't have to be a federally licensed dealer to sell a gun. And anyone could sell a gun. And if anyone sells a gun, a so-called private sale, other than in a few states like California, they don't have to do a background check. And that means a significant but unknown number of lawful gun sales happen without a background check.
We should be clear, a licensed gun dealer selling guns at a gun show is still required to conduct a background check, and they do. So Adam's right. It's not the gun show loophole. It's the private sale loophole. But the private sale without the background check is illegal in California today. And so the transfer of the two AR-15s to the couple that did the San Bernardino shooting was already illegal in California. And having that law on the books, of course, didn't stop that transfer from occurring. One of the great the issues in the gun control debate is, are these added layers of gun control going to actually stop the people who are violating the laws that are already on the books when they engage in their mass shootings or what have you? And the answer is they're of course not going to stop those conduct. They're already violating the law on the murder. The weapons that this couple had included pipe bombs, which are not legal under any version of the Second Amendment, and that didn't stop them from preparing those either.
There's no doubt that the government could require that anyone who sells guns be registered and that they do background checks. If you make it harder for people to have guns, you can keep guns away from some people who are very dangerous. You might not have prevented last week's tragedy, but you will prevent some tragedies. And experience in foreign countries shows the less that guns are available, the less there will be gun violence.
Is the Second Amendment always going to be subject to the political leanings of the court? Is there ever going to be an end to the debate over whether it's like it's an individual right or a right for militias? Your thoughts on that?
I think if Heller becomes a settled part of our jurisprudence, both in recognizing a right to bear arms and legitimate space for the government to adapt public safety laws that regulate guns and gun owners, I think eventually that we can move forward and break out of the spiral that seems to take us towards ever more extreme positions on guns.
Yeah, I think Judge Posner's critique has been dismantled piece by piece by many of Scalia's defenders, including most prominently Ed Whalen. What he really wanted is for Chicago to be able to regulate guns, so when he's walking home from the courthouse, he didn't have to confront it. But the people that he's likely to run into on the Chicago streets walking home have their guns illegally in the first place, by and large. They are already engaged in criminal conduct, and so the notion that a new layer of restrictions is going to somehow make that walk safer, I think, is just naive, and Judge Posner seems to have walked right into it.
The reality is that you're not going to resolve the meaning of the Second Amendment through originalism. The language of the Second Amendment can be read for either view. So it's not surprising to me that the 5 conservatives on the court took the position favored by conservatives, and the 4 more liberal justices took the position favored by liberal justices with regard to the Second Amendment. I think that this dispute will go on as to the Second Amendment into the future. I'm hopeful that what Adam says is right. I'm hopeful that the direction he points to in his brilliant book is right, that there might be a middle course that recognizes the right to have guns but allows regulation. But I don't think that this debate is going to be resolved anytime soon.